Kate explained, over the years we felt that teams that arrive on day one without the benefit of a coach are at some disadvantage compared to those teams that arrive with a coach. Now, of course, over the course of the week, everybody learns very rapidly, and so the gap quite quickly narrows. But it seemed to us a pity that any team, simply because logistics meant they don't have a coach, should start under any sort of disadvantage. And therefore we're using this session as an opportunity for you to put questions to me, and also for me to put some points to you, which I think I've got 8 tips. I was trying to get to 10, but the train got to the station, so I had to get off. Tips out of my experience, and I have sat as an arbitrator in the competition now many times, both in the general rounds and then in the quarters and the semis and even in the finals. So I am speaking out of my own experience, but you do have to remember that this is only one arbitrator who is talking to you, and every arbitrator is different and may have different preferences, but in what I will say to you, if you'd like to hear it, I have tried to be general rather than too particular to David Martin-Clark. I think it might be helpful if the teams just introduced themselves in the sense of saying who is in the room, so that we know who is here. And I think you're part of the SMU team, right?
Yeah, the 2 of us and my colleagues over there, Joey and Kim.
Okay, so SMU is split.
Oh, no.
You're obviously for the claimants. Yes. So we have SMU, and then we have Murdoch, yep. Yes, and we have Victoria University from Melbourne. We have here National Law School of India. We have Sri Lanka Law College.
And from City University of Hong Kong. City University of Hong Kong.
Oh, City University of Hong Kong. Okay, that gives us what, 6 out of the coach teams. Okay. I know that starting these sessions is always a little bit tricky, who is going to speak first and so on. So I thought I would just start us off by saying that as lawyers, as advocates, and here as mooters, your job is to persuade your tribunal. So you're engaged in an act of persuasion and not coercion. I have had occasions where some advocates have treated the tribunal as the enemy and have therefore spoken at it in what I would call a volume and a tone of voice, which I would suggest is inappropriate. What you're trying to do is to persuade me that the submissions you make are the ones that I should accept because they are correct. Now, to do that, it is helpful, and I know that some societies find this difficult, but it is actually helpful to have eye contact. It is quite difficult for basically the tribunals you will meet here to engage with an advocate whose eyes are always modestly cast down. So I would suggest that eye contact, if you can manage it, is an important point. In terms of pitch, you need, in order to persuade, to ensure that what you say can be heard. And there's 2 problems here. One is that some of you inevitably, with English as your second language, or maybe even your third, will speak with an accent that will not be immediately understood by all your tribunals. So to speak clearly is important, because if your tribunal can't hear you, then it can't judge. And that leads me to this point, that you have very little time. Each speaker, has 15 minutes, Kate, only? And you have a brief that runs to 70 pages, and your memoranda go to 25 pages and so on. And the number of potential legal points is enormous. Now, you cannot cover the field in 15 minutes. So it is very important, in my view, to be selective about the points you want to argue. You cannot argue all points. Most of them you'll have to leave to one side. So it is necessary in your preparation to work out what are the real points in issue on which you should concentrate your time and attention. And if you concentrate only on a few points, that means you can deal with them at a pace which enables your tribunal to understand where you're coming from, what you're saying, and what the importance of what you're saying is. There is a temptation, inevitably, because you're conscious of that clock, to talk against it. And to push it out because you've got it on your sheet in front of you. Come and join us, come and join us.
Sorry, you're late. Sorry.
No problem.
No problem. It's not better that you're here than not.
Yes, better here.
So have you got 2 new teams coming?
Yeah, we are from Kerala Law Academy.
Okay. And?
National University of Singapore.
Okay. We haven't yet got to the questions because I've taken the opportunity to, as it were, just make a few opening points. And what I was saying was that because your time is so short, 15 minutes a speaker, you cannot cover every point. So the selection of the points you want to argue is crucial. And if you keep them limited, then you have time enough to speak to them without gabbling. Because it's very difficult for an arbitration tribunal to understand quite what you're trying to say when you are very aware of what is on the clock, and therefore you're saying, no, but I want to look at page 46, because we haven't got time to look at page 46, so therefore, let's have a look at the chart, but we've got time to look at that either, and therefore there's the case of, so that's very important too. At the end of that, your tribunal is completely lost. The speed of speech, pitch of speech, and remember that you'll be talking as arbitrators usually to a generation that is at least one stage older than you are. And just be aware that as people age, sometimes their hearing is not as crisp as it was when they were in their 30s. So again, audibility, pitch is important. Because you want your tribunal to feel comfortable with you and to say, well, that's a very interesting point. And we'll come to questions in a minute. In other words, the questions that the tribunal puts to you and how you should deal with them, or how you can deal with them. Because the tribunal wants to ask you questions. And in fact, Kate will brief her arbitrators. Ask them questions, see if they know their stuff. So you will get questions from your arbitrators, and therefore some thought as to how you're going to answer those questions is valuable. Okay, I said enough to open. Let's take some questions. Who's going to be brave enough to ask the first question?
When you referred to pitch of voice, where does modulation of pitch fit? Do we keep it, I'm going to say flat, or do we...
No, I think what you want to do is you want to catch the tribunal's interest. And therefore, if you've got something that is really crucial to say, you may need to lift your pitch and hold it, because the tribunal says, crucial? I better pay attention. Yeah. So a monotone is, I think, likely to induce sleep. Better avoided in the context of the mood. Thank you for your first question. Now, anybody else? Can I see one over here? From you, yes.
How do we address the members of the tribunal?
Good question. Good question. I thought that would come up, and I thought I'll ask Kate how she'd like it handled, but I forgot to do so. Kate, what's the most, the easiest way?
I think I think whatever you would advise them would be appropriate.
Well, I would say this. You'll have 3 in your tribunal, won't you? You'll have a chairman, a chairwoman, and 2 wingers. I think the easiest thing is to say, Mr. Arbitrator, or Madam Arbitrator, And if that person happens to be the chair that you're addressing, you can say Mr. Chairman or Madam Chairman. It is not necessary to follow the tradition in some courts of talking about the honourable arbitrators, the learned and distinguished arbitrators, and of course we know that they're learned, distinguished and honourable. So I think that we don't have to worry about that. Mr. Madam Chairman, Madam Chairman, Mr. Chairman. Sir is not necessary. I know that's very often used in court. You certainly don't have to, as we do here, have to talk about your lordship, or as you would have to talk about your honour in Australia and elsewhere. That is not necessary. We're an arbitration, and one of the features of arbitration is its informality, or its relative informality, compared with the courts. Politeness, yes, but over-deference is out of place.
There is one exception to that, which is the grand final, which I'll talk about in the
well,
briefing.
briefly, when you all get to the grand final.
That's right. I'll sort you out when that comes.
Yeah. But I'm talking about whether dealing with ordinary mortals, the general rounds, and the quarters, and even the semis too.
Absolutely.
I mean, what your arbitrators want is, if you like, a polite and civilized relationship with you, because they're interested to hear what you say. And anything that builds up that atmosphere of confidence is going to happen. Okay, 2 questions. Third.
How do you represent ourselves as counsels?
Okay, well, usually each tribunal asks for what we call a list of appearances, Kate. And that simply says that which university is arguing for claimant, which university is arguing for respondent, and remember that you will, in the course of the moot, you will switch between them. And we will normally have counsel who speaks first, counsel who speaks second, on both sides. And it is usual and quite helpful, I think, for the counsel who's going to speak first to remind the tribunal whether he's for the claimant or the respondent, and to introduce himself or herself and his, sometimes we call them assistant or co-counsel, isn't it?
Either of those is fine.
Say again?
Either of those is fine, yeah. And also you will fill out an appearance slip before the tribunal comes in, which will have your names on it as well, and we hand that to the tribunal so they have your names before them, and they will transcribe that onto the score sheet.
And certainly a number of the tribunals will actually, if the pronunciation of your name is not clear, to basically, I would say to me as an English, I won't always know where the stress or the emphasis should come in pronouncing your name. Certainly I've seen many chairmen say, oh Miss, how do we pronounce it? How should we address you? Should it be Miss that, or Miss that? That's it. So you give them some guidance, because they want to have a dialogue with you that is polite from them to you, as from you to them. So they may need help with names with which they're not culturally completely familiar. Okay.
Sorry, may I ask a question? Just in terms of commencing the process, reference to time, so we've given appearances, would we then nominate immediately the time frame, or is that beholden upon the claimant to nominate?
No, I think each side would indicate to the tribunal how it wants to use its time, but each speaker has got to have a fair amount of time. You can't say my lead speaker will speak for 27 minutes and my co-counsel for 3. It's got to be pretty evenly divided. It doesn't matter if it's 16-14, but what it can't be is 25-5. And you would normally, if you're the opening counsel, having made your introductions, you would say that the points on which I shall concentrate are deviation or conversion or cargo damage or whatever it is, and my co-counsel will deal with issues of jurisdiction and incorporation of child party arbitration clauses or whatever it's going to be. But you again, that helps the tribunal because they're meeting you for the first time. There's only half an hour for each side, as it were, to make its impression. And the more you can get your tribunal comfortable that it understands what is going on, because at times the tribunal does not understand what is going on, the better it is for you. And on this, I would say if you can, I personally find written skeleton arguments enormously helpful. They shouldn't be more than 1.5 sides of A4, but they will say, Council 1 is addressing points 1, 2, 3, Council 2 is addressing points 4, 5, 6. And when sometimes your tribunal will get lost, to have a skeleton there is marvellously helpful because instead of the tribunal having to say, excuse me, where are we just at the moment, which is rather undignified, you can say, oh yes, of course, we're at point 4. I again know where I am as a tribunal. So if you can do it, it's quite a good guide for you too. Skeleton, come in. Skeletons are helpful. And once you've done them once, for each side, you won't have to do a lot of retuning every time you remoot. You may want to say, I'll take out point 5 because it doesn't seem very important and put in a new one. But once you've done the work, once you've made the investment in what I'm talking about, skeleton argument for the benefit of your tribunal, a short skeleton argument, once you've made the investment in it, I think it will yield return because it will be there to help you every time you move. Welcome, you are from?
Swansea University. Sorry, we got lost a little bit, yeah.
Yeah, well, you had to travel. Yeah. Nice to see you. Yes, we got lost too. Okay.
David, I'm sorry, an adjunct to that question.
Yeah.
The differential between procedural and substantive argument. The claimant, I assume, introduces themselves and gives appearances in the respondent. Am I correct? At that point, you're suggesting a time allocation as well. The argument then proceeds to a procedural one.
Well, depends what you mean by procedural. Your tribunal, I think, is going to be wrong-footed if you say that you can say it has no jurisdiction, because tribunals are used to being told they have no jurisdiction. But to say that the tribunal can't hear the case because there hasn't been compliance with the Civil Procedure Rule 37(4)(b) is going to delay proceedings, take valuable time, and if it's not actually available to you in the documents, don't take it, I would say. What the tribunal is interested to hear is your views on what I call the substantive issues that the problem raises, not on any procedural irregularities unless they concern a time bar. And I don't think we have a time bar problem in this case. But otherwise, I would concentrate on issues of substance rather than issues of procedure. And I don't think, if you have a clarification on issues of procedure, I would honestly suggest you clear that with Kate in advance. If it's a genuine not fully understanding what the case is presenting to you in procedural terms, I would try and deal with that outside the moot room. The two reasons for that. One, it takes a little time. B, your tribunal may not actually be in a position to answer the question for you if it is procedural.
Well, there's moot procedure and there's procedural issues that might be raised on the facts.
Okay, that's a fair distinction.
So the procedural issues that might be raised on the facts are part of what you might be expected to deal with in the tribunal.
I apologise. I meant procedural issues on the facts.
Okay.
I wasn't concerned.
But I think what David says is correct, though, is that you certainly don't want to spend 15 minutes of your 30 minutes talking about the procedural issues. If you think there's something of substance there to deal with, you deal with it hard and fast, and you move on.
Yep. I understand that. I suppose my question was more in relation to how it rolls out. So the claimant's introduced, the respondent has introduced, I assume, who then commences with procedural?
Well,
it's a matter for discussion, I think.
Between the parties, agree who might go first. certainly sometimes when there's a key issue of jurisdiction, the person who is challenging the jurisdiction might go first on that issue. Otherwise, I think if there's enough agreement between the parties and the tribunal will call the shots, and normally the tribunal will simply say, let's hear from the claimants first, after all, your people are wanting something, as you would expect in court.
You can expect it to go either way, you know, and it's up to the tribunal whether they want to hear from the respondent who's challenging jurisdiction first or the claimant on the substance first. And you've got to be prepared to wing whichever way the tribunal wants, is my experience.
Just remember, we've got a flexibility in arbitration in particular that the courts may find more difficult. One of the attractions of arbitration is that it is, in terms of its procedure, pretty flexible. As long as there's essential fairness between both sides, most things can be managed. Is that enough?
Thank you.
Excuse me.
Yeah.
As a leading counsel, will there be a necessity to discuss about the facts of the case at the beginning?
Oh, that's a good question. Yes. If you were in arbitration for me, or certainly in court, you would start by just making sure that your tribunal knew the essential facts of the case. And that could take the first half day. Now, we haven't got that here. Now, I think it is fair to say you can assume that your tribunal will have read the same papers that you've read. But remember, you've been working on them for 5 or 6 months. Your tribunal may have read them once or twice. So if you have a key point, well, whatever comes out of it, in terms of opening, I would suggest that you need to do no more than make what I would call a 2-sentence summary, that this case is essentially about the misdelivery of what we believe to be a valuable cargo of PFAD at Rotterdam in March 2009. Okay, that sort of switches your tribunal on that they know they're not hearing a sort of like an infringement of patents case. So they're with you in terms of what is going on. Now, in terms of the facts, firstly, your tribunal will expect you to know them backwards. So try not to make mistakes on facts. Because if your tribunal finds out that they actually know the facts of the case better than you do, then that's not terribly impressive. And it sometimes happens. And it can sometimes happen by mistake. You get a page wrong number and say, oh, forgive me, the correct page number is 54, not 45. It doesn't matter. That doesn't matter. But to be in a muddle as to the role all these parties are playing, whether they're brokers, whether they're buyers, whether they're sellers, whether they're charterers, whether they're ship owners, that you should have really imprinted on your brain. And you may find it, and I certainly do, easier to describe a buyer as a buyer rather than as a claimant or a respondent. Because these labels, claimant and respondent, depending upon whether we're dealing with a claim or a counterclaim, can get very muddy. But a buyer is always a buyer, and a seller is always a seller, and an owner is an owner, and a charterer is a charterer. Or you can say, if you don't want to describe them in roles, you can talk about Beatles, oils and fats, and BOF, whatever they may be, or aardvark. And in fact, by using the names, you give an immediacy, a sort of a reality to what is going on. You know, if you are representing aardvark, you're talking about a real client who spent real money, don't go too strong on the sob stuff, but I mean, you know, your client is at the moment in about $3 million out of pocket, and it's got a complaint to make. And okay, you can say that is the table, but if you refer to aardvark, then okay, I'm looking to take a picture of who aardvark might be, and I think that if you give the aardvark, you promote, or you promote more sympathy